Well, thank you first of all for inviting us to present on our new ordinance. I think we have been presenting to you guys for some time now, so hopefully the first few slides I'm going to go through will actually be revision for you, not too much work. But I will introduce in more detail some of the more difficult areas that we have been involved with, and hopefully that will give you a little bit more information. As I say, the first few slides should be revision for you, the background to the Companies Ordinance rewrite, which I'm sure you're all familiar with, endorsed by LegCo in 2006, dealing only with the provisions in Cap 32 relating to live companies. The winding up insolvency-related provisions and the prospectus provisions will remain in Cap 32, which will be renamed the Companies Winding Up in Miscellaneous Proceedings Ordinance, or affectionately known as QWMPO. And this is in the process of being amended at the moment. There is some work being done on the insolvency provisions, which again I'm sure you're aware of. It was introduced, the bill was introduced into LegCo in 2011, and after about a year and a half of very intense deliberations, lots of meetings, lots of papers discussed, lots of amendments made to the original bill, our bill was actually passed by LegCo on the 12th of July 2002. Since then, we've been busy with the subsidiary legislation, and we'll perhaps give you some more information about that later. So the ordinance itself, the new CO, I'm sure again you're familiar with the structure of the ordinance. It's 21 parts, 921 sections, 11 schedules, 12 items of subsidiary legislation, the final batch of which was enacted by LegCo on the 17th of July this year. So we've just really finished working on the subsidiary legislation, and that's all gone through quite smoothly, and that's also now on our website if anybody's interested in having a look at that. So we really are now geared up to commence, and our D-Day is the first quarter of 2014, so probably sometime around the beginning of March is when we're hoping to have the new ordinance effective. As I say, divided into 21 parts. The structure is set out in the presentation. I shan't go through the parts, but it is quite, hopefully, coherent, clear, divided into very definite sections, and it should be easy for people to work their way around. It is much longer than the current Cap 32. That is attributed to one of our policy objectives, which was writing in plain English. Guess that means plain English is much longer than we thought it should be. It's now 3 times as long as the original ordinance. But we hope that introduces clarity, coherence, and it should be quite easy to follow. That's the plan. The 4 objectives behind the rewrite, again, something I'm sure you're all familiar with. So enhancing corporate governance, ensuring better regulation, facilitating business, and modernising the law. So these were the main objectives behind the rewrite, and hopefully, after you've considered it, you will agree that most of them have been accomplished. So today I'm going to look at some of the initiatives under modernising the law. So we've streamlined the types of companies that can be formed. We've abolished the Memorandum of Association for all companies. This is a topic that I've spoken on a couple of times to the organisation. So again, I hope this is revision rather than something new. Retiring the concept of par for all shares. Again, we've touched on this before, so hopefully this will now be becoming familiar material for you. With the initiative of ensuring better regulation, we've lowered the threshold for contravention by officers with the introduction of the responsible person formulation. We've improved registration of charges, and we've introduced a power for the registrar to compound certain offences. With a view to facilitating business, we've introduced a new alternative court-free procedure for reducing capital. We are allowing all types of companies to purchase their own shares out of capital, and all types of companies to provide financial assistance to other parties to acquire shares in the company or the holding company. So, without further ado, the first initiative streamlining the types of companies that can be formed. I'm sure you're all aware that under the current CAP 32, there are in fact 8 types of companies, different types of companies that can be formed. And I've set them out in this slide. So we have the term private and non-private, companies limited by shares, guarantee, unlimited with share capital, and unlimited without share capital. So we have 8 companies. In fact, until 13th of February 2004, there was another type of guarantee company with a share capital, but these companies were grandfathered as from the 13th of February 2004, so they haven't actually been part of our company law for some time, but there are still such companies in existence. So unlimited companies without share capital have been completely abolished under the new CO. No magic to this. This is simply because there were no such companies on the register. And considering the way that the law has developed in this area, it was really thought there was never going to be any need for this type of company, this type of corporate vehicle. So this has been abolished altogether. Companies limited by guarantee, whether private or non-private, they have now been amalgamated under the new ordinance just to form one type of company. So there's a separate category of company, just a company limited by guarantee without a share capital. It doesn't say that, but that is the essence of it. And they will generally be treated the same way as public companies, so they will be required to, for example, file accounts with their annual returns. We've introduced the term public company rather than non-private, which we have under the current CAP 32. This is no substantive change, but it just reflects essentially what people consider to be the position. And the definition of public company is basically a company other than a private company or a guarantee company. So as a result of these changes, there are now essentially 5 types of companies that can be formed in Hong Kong. Again, I've set them out in the slide. I think the reality is, again, the unlimited company is not going to be a vehicle that is going to be much used. And the real reason that this wasn't abolished was just simply because there were already some such companies. I think there's 13 companies on the register at the moment, so it actually wasn't possible to abolish this category of companies. There are at the moment some private guarantee companies. They will become just companies limited by guarantee under the new ordinance, and I think there's about 125 of these companies who will remain the same, but their obligations will change with the commencement of the new ordinance. And I think the registrar is undertaking an exercise where she will write to these companies individually and inform them of their new obligations under the new law, because they will now be required to file accounts with their annual returns, so quite a change for these companies. But really no major changes, even though it is quite significant, it looks quite significant. There shouldn't really be a lot of practical problems with these changes. And in reality, the major types of companies we now have will be public limited by shares, private limited by shares, which is of course the bulk of our corporations on the register, and companies limited by guarantee. The next topic that I'll have a look at is the abolition of the memorandum for all companies. Again, I say we've gone over this before. Everybody thinks this is quite a radical departure from the conventional company law situation, which of course it is, because the memorandum has been around forever. But in practical terms, hopefully this really shouldn't cause too many problems, particularly the way that we have introduced it in the new ordinance. With the abolition of the ultra vires rule in 1997, it has long been recognised that the objects clause or the memorandum has become a less significant document in a company's constitution. Now most of the terms in the memorandum, most of the provisions can be amended. The authorised share capital can be amended by ordinary resolution. And really the need for a separate constitutional document like a memorandum had diminished. It had become a little bit outdated, with most of the terms being able to be amended, and with all companies having the rights of a natural person, full capacity of a natural person. So a decision was taken to abolish the memorandum for all companies in Hong Kong. Again, this on day one, all companies, no memorandum. And Section 67 of the new CO sets out how a new company can be formed. So it will be by delivering the incorporation form and a signed copy of the Articles of Association. So that contract by the subscribers to take up shares, which traditionally forms the basis for the incorporation, is now met by the Articles of Association rather than the memorandum. Just point out, this is a little bit different from the situation in the UK, where they have actually retained the memorandum, albeit it only contains this very simple contract to subscribe by the founder members. But this will be a vestigial document, a historical document that will not be changed. It will just be there as that contract which founds the basis for the incorporation. So we're a little bit different from the UK. It will be our articles now that have that basic agreement to incorporate by the founder members, their agreement to take up shares in this corporation to be formed. And I've set out in the slide the actual procedural requirements. The signed articles don't actually have to be filed with the registrar, but there has to be confirmation that the articles that are filed are the same as the ones that have been signed. So no need for a signed copy to be formed, but there has to be a confirmation that this contract actually does exist. So companies are now required to have mandatory articles. And surprise, surprise, the mandatory articles are essentially the same provisions that were originally contained in the memorandum. So your name, statement of liability, whether it's limited or unlimited, capital and initial shareholding on formation. These are mandatory articles that every company will be required to have. So now on incorporation, what will be filed will be the incorporation form and these mandatory articles of association. There are some optional articles, which I've also set out in the slide, and that is basically you can have an objects clause if you want to. You don't need to unless you're licensed to dispense with use of word limited in your name. And you may state the maximum number of shares that a company may issue. So this is not mandatory. So this is kind of in place of authorised capital, but it's not mandatory. And I suppose it's to give some kind of against dilution, you know, some kind of assurance against dilution, although it can still be amended by ordinary resolution. Subsidiary legislation, one of the last pieces of subsidiary legislation that we enacted this year were the Model Articles of Association. So these will be the additional regulations for the companies. The Model Articles Notice, LN 77 of 2013. It prescribes model articles for 3 types of companies. So the public company limited by shares, which is set out in Schedule 1, private company limited by shares, Schedule 2, and guarantee company, Schedule 3. So these basically replace tables A and C in CAP 32. Slight difference, whereas under CAP 32, it's only table A that applies by default. So the other table C is a form of articles that has to be adopted. Under the new legislation, all of these model articles will apply by default unless otherwise modified, excluded or altered. So that is another difference. For all of these companies, there is these model articles that can be applied automatically. So they, as I say, they will apply by default if no additional articles are filed by the company, or even if articles are filed, they will apply insofar as they are not excluded or modified. So similar to Table A, but when incorporating, if you don't want them to apply, either you have to exclude them completely or make it clear that they're being replaced by something else. Actually now, with the model articles and the filing of the incorporation form and the mandatory articles, it really never has been easier to incorporate companies. Essentially, all the company really needs to file is its mandatory articles, its incorporation form, and if it files nothing else, it will have a full set of articles as set out in the schedule to the model article notice. So it should really be very conducive to e-incorporation, and hopefully it will be welcomed by the community at large. So we've got 1 million companies with a memorandum. What does this mean for them? Well, I've set out on the slides again. The ordinance deals with this. Basically, section 98, there's a deeming provision. Conditions of memorandum of existing company immediately before commencement deemed to be a provision of the articles, except any condition relating to authorised capital or par value are to be regarded as deleted for all purposes, and that will tie in with the abolition of par. And then all references in other ordinances or documents to memorandum is deemed to be a reference to the Articles of Association. So the deeming provisions really should ensure smooth transition for all existing companies. Having said that, again, we are saying any companies that really want to have a look at their articles to make sure they're new CO compliant, this is a good time to do it. And if you want to compare your articles to the new articles, see if you need to make any amendments, again, this is a good time to do it. The way to change the articles is all set out in the ordinance, but there's no great change from current CAP 32 requirements in that regard. So moving on to the next initiative in modernising the law, retiring the concept of par. So nominal value or par value, I think, it's the minimum price at which the shares can generally be issued. And I think it's been generally accepted for a long time that it really doesn't serve the original purpose of protecting creditors or shareholders. I mean, there's no guarantee. The par value really has no reflection of the actual the real value of the shares, and it gives no guarantee of any minimum amount of capital that the company has. So the new Companies Ordinance adopts mandatory system for all local companies and retires this concept of par totally. This is in line with international trends. Most other jurisdictions are introducing similar provisions. It's not been done in the UK. I think it's simply because of an EU directive which prohibits that being done at the moment, but we understand that the intention is in the UK for them to migrate in this direction in due course when they can. So it's adopted Australia, New Zealand, Singapore, South Africa, and it's been introduced with absolutely no problem in most of these jurisdictions. So we're not anticipating any great difficulties with this. So essentially there's no difference between a share of no par value and one having a par value. Both represent a share, being a fraction of the equity. But the par value has a fixed face value to the share, and the share without par doesn't. But that fixed face value doesn't reflect at all the actual value or the share in the equity of the company. So we consider by retiring this concept, we create an environment with greater clarity, simplicity, and really it should be welcomed by the business community generally. So what are the major changes? Under CAP 32, every company in Hong Kong having a share capital are required to have a par value ascribed to their shares, the minimum amount at which the share can be issued, and it can't be issued under that value, prohibition against issuing shares at a discount. And companies must declare in their memorandum the maximum amount of share capital that can be issued, the authorised share capital. The excess of the issue price of the share over its par value is designated as share premium. And under CAP 32, there are restrictions on how share premium must be accounted for. So under the new CO, as a result of migration to no par, relevant concepts such as par value, share premium, requirement for authorised share capital are actually no longer necessary, and they are abolished under the new CO. So authorised share capital. So upon commencement of the new CO, the provisions in the memorandum of an existing company relating to authorised capital and par value are regarded as being deleted. So that's section 98, which I've just touched on with the abolition of the memorandum. So even for existing companies, nothing needs to be done because there is a provision stating that these provisions currently in their memorandum will be regarded as being deleted. So the full proceeds of a share issue will now just be credited to the share capital account. Under the new regime, that will just be the company's share capital. The notion of issued or paid capital will continue to be relevant, and it will include what was previously known or what we previously attributed to as share premium. So the share capital will represent the total amount that the company actually receives from its shareholders as capital contribution. So this does create a much simpler, clearer environment, and I think it will be much easier for people to understand. It becomes less the domain of the accountants, and it's just a much more simplistic, realistic approach. The share premium account will, with the abolition of PAR, it will no longer exist. And there's a deeming provision for amalgamation of the share premium account with the amount of the company's existing share capital. That's in the transitional provisions in Schedule 11. But just to flag this up, the currently permitted uses of share premium which exist on the date of commencement of the new CO, so for example, to pay up shares which are to be issued as bonus shares, that it will be retained for the balance outstanding at the date of commencement. So companies really should continue to maintain a record of this amount until it's all used up, because they can continue to use it for the purposes for which they can at the moment if they so wish. Capital redemption reserve, on the commencement date, any amount standing to the credit of the capital redemption reserve, again, just becomes part of the company's share capital. Again, coherent and simple. So we hope this will create a clearer business environment in the company. It will be easier for it to structure its share capital. It will have more flexibility in how it wants to structure its share capital. For example, in a no-par environment, it will be able to capitalise its profits without issuing any new shares. So the effect of capitalisation of profits will simply be the share just grows in value. Equally, it can allot and issue bonus shares without increasing the share capital. The share will just reduce in value. So simply this share is automatically reflecting the value of the company's share capital without any need to transfer funds to and from share premium account. So much simpler, much easier to understand. They'll be able to consolidate, subdivide shares, and it's really going to be quite easy. There's going to be no magic to it. So the process of consolidating into smaller numbers should be simplified where there's no par to contend with. The number of shares will just reduce and there'll be no visible effect on the actual share capital. Bonus shares can be issued, notwithstanding there's no longer a share premium account, because in a no-par environment, shares can be issued without transferring any amounts to the share capital account. So again, simplicity, flexibility. Transitional arrangements. The new CO, as I say, will commence first Q1 2014, and abolition of PAR takes place on day one. It's all local companies, regardless of whether or not they're formed before or after commencement date. The law will just simply deem all shares to have no par value, and that's section 135 of the new CO. No conversion process required, so again, nothing much for companies to do. We have got detailed transitional provisions. I've set out some in the literature here. I urge you to have a look at that. It refers to, for example, contracts, documents which ascribe rights by reference to par value. There is provisions for what has to be done or what will be considered, normally the voting rights. So it's quite straightforward. There are deeming provisions, and we're hoping that it will be introduced without too much difficulty. Again, we are saying, however, this is a good time for companies to look at their constitutional documents, to look at their shareholder agreements, to look at the documentation that they consider may have to be revised or considered in light of this change, especially where there is a lot of rights by reference to par value of shares or whatever, and consider whether or not they need to do anything. But it is a matter for them, and nothing really should require to be done. We have issued an external circular on this topic, and I've given you the link to that. again, just to highlight, there is a lot of stuff on our website, a lot of materials, so if you do have an opportunity, I do urge you to have a look at it between now and the new ordinance coming into effect. Third topic I'd like to look at, the responsible person. Again, I think this is something I flagged up before in this forum, and this is lowering the threshold for contravention by officers of a company. I'm not going to take too long on this because it is quite technical, quite legal, and I think all you really need to know is that whereas under Cap 32, that you had to, an officer, a director or company secretary could only be prosecuted if they knowingly and willfully breached the ordinance. This is no longer the case under the new ordinance. It was considered that most of the obligations are regulatory, minor breaches, and the threshold of knowingly and willfully was very, very high. As a result, it's been very difficult over the years to prosecute culpable directors because willful requires this proving of deliberate intention to breach the ordinance. And it was just considered that that was too onerous. So the responsible person is now defined in the new CO Section 3 as an officer of a company who authorises or permits or participates in the contravention or failure. So reckless conduct will be prosecuted. This will include turning a blind eye or willful blindness. So something that you really should have known but you chose not to know. Negligence is not, however, being targeted. The effect of the new formulation will be to lower the prosecution threshold just to remove this willful element. The original proposal was a little bit more ambitious, and actually it did, we were trying to pull in negligence. We had followed the position in the UK, Section 1121 of the 2006 Act, and there was an additional limb of failing to take all reasonable steps to prevent the contravention, which is really an objective standard. This caused quite a lot of concern going through LegCo, and the Bills Committee were not happy with it. So after a lot of reflection, a lot of deliberation, a lot of legal advice, we agreed to back off, and we are still happy that our objective has been achieved, that we are lowering the threshold, but not as much as they really wanted to at the outset. So hopefully it will have the effect of ensuring better regulation, and that can only be a good thing for everybody, I think. So just to be aware that this threshold has been lowered. Registration of charges, again, I don't think this is something that will really affect you guys much, so I will be very quick on this. There's not a lot of changes. The regime, in essence, remains the same. Issues that you do need to be aware of is that the time for lodging a charge after creation has been reduced from 5 weeks from the date of creation to 1 month. So there is a shorter window of invisibility of that charge on the company's register. And that will hopefully, again, just ensure the integrity of the register is upheld, and that people are more aware of obligations that are being created by companies. The other major change in relation to the registration of charges, there's been a slight change in the list of registrable charges, but it's quite technical. I'm not going to go into that. Is a certified copy of the charge instruments itself will be placed on the register. So at the moment, there's a specified form with prescribed particulars. The original charge is lodged with the registrar. Registry staff meticulously check the information in the form. It's the same as in the document, which is relatively onerous because we have to identify the property, we have to identify exactly what is being charged, and that can be quite complicated. The documents can be quite lengthy, and it does actually cause quite a lot of work for the registrar. So basically the onus is now being shifted to the public. The whole document will be put on the register, and it will be up to the searcher to check exactly the contents of the document, the subject of the charge, and to make sure that they are aware of what has been charged. This is going to have an effect on constructive notice, so lenders will have to be very, very careful if there is a negative pledge or a crystallization clause. They will be most likely deemed to be aware of that when they're lending. So hopefully it should mean people are more diligent, they pay more attention, and they sort out their priorities before they actually lend money and before they take out their own security. Compounding. This is a new initiative under the Companies Ordinance. I think it does exist in Hong Kong under, I think it's the Inland Revenue Ordinance, and there is somewhere else. But this is quite a new idea for the Companies Ordinance, and this is basically again to enhance regulation and to optimise the use of judicial resources, encourage compliance with the new CO. At the moment, Registrar has a range of measures to encourage compliance, and this is basically building on that. It's based on the Australian penalty notices system, and there are specified offences which are set out in Schedule 7 of the new CO. I've listed all of the offences. There will be some more offences added at the end of this year. We're in the process of amending the schedule. And for these particular offences, where there is a breach, the registrar is given a power to compound rather than to prosecute for the breach. So if she's reason to believe that one of the specified offences has been committed, she gives the company notice in writing, which will state that she's reason to believe that the company's committed the offence and set out the particulars of the offence. The conditions upon which no prosecution action will be taken will be set out in the notice. That will normally involve detailing the amount of a compounding fee to be paid to the registrar, period within which conditions have to be complied with. So, for example, if it's failure to register an annual return, they will be asked to lodge the annual return, say, within 15 days of receiving the notice. And if they file the annual return and pay the compounding fee, no prosecution action will be taken. No, both have to be done. You have to do the act that has to be done and pay the fee. If either one's not done, prosecution action may still proceed. The compounding fee will be initially set at $600. The payment of the compounding fee will not be an admission of liability. The notice can only be issued before proceedings for any contravention are commenced. So once a summons has actually been issued, there will be no possibility for compounding. So it's a pre-prosecution process. The offences will be confined to those set out in the schedule. And those offences have been chosen particularly because they are straightforward, regulatory in nature, punishable only by fine, and easily identifiable by objective evidence. So there's no question of mens rea or any kind of defence that could be lodged. It will be very clear-cut cases. The major area where this is going to impact will be the filing of annual returns for local companies and for registered non-Hong Kong companies. So rather than prosecute, it's likely that compounding will take place in relation to any non-filing of these documents. So I think this is the final area under the initiative, the policy initiative of facilitating business. The changes that we have made in relation to transactions in relation to share capital. So we've introduced a court-free procedure for reduction of capital. This is all set out in Part 5 of the new CO. It's very meticulously drafted, detailed procedural requirements are set out, so it should be hopefully very easy to follow, but quite detailed. I'm just going to give you the bare bones today. So Cap 32, as you know, only allows a reduction of share capital if it's approved by the shareholders by special resolution and then approved by the court. So quite laborious, quite expensive, detailed procedure. So the new CO introduces an alternative procedure. and it's court-free, based upon a solvency test. This should be faster, cheaper, and can be utilised by all companies. Section 215 to 225 set out the detailed procedures, and as I say, I'll just set out the key features today. So first of all the directors need to sign a solvency statement. Members' approval is still required by special resolution, and then notices have to be filed in the Gazette and newspapers of the proposal. The solvency statement has to be registered with the company's registry. Any creditor or non-approving member of the company may, within 5 weeks after the special resolution is passed, apply to the court for cancellation of the resolution. And if there is no application to the court, the relevant return will be filed with the company's registry after the expiry of the objection period, and the reduction will take place on the filing of that notice. So not before the 5-week objection period has expired. Share buybacks out of capital. Again, under Cap 32, general rule, company can only buy back its shares using distributable profits or using the proceeds of a fresh issue of shares. So this is derived from the capital maintenance rule, but there's an exception at the moment for private companies who can fund buybacks by payment out of capital based on a solvency test. Under the new CO, we've introduced this for all companies. So all companies are allowed to fund buybacks out of capital subject to a solvency requirement. This is set out in sections 258 to 266 and retains most of the Cap 32 requirements and procedures applicable at the moment. And the requirements and procedures are similar to the new court-free procedure for reduction of capital. The final area where we've made some changes is financial assistance to acquire shares. This has always been a little bit more debatable because arguably it doesn't offend against the capital maintenance rule anyway. So we tried to be a little bit more liberal with this. I think at one point we were going to abolish any prohibition altogether, but that was just a little bit too ambitious, so that has not manifested. Currently, Cap 32 prohibits a company and its subsidiaries from giving financial assistance for acquiring shares in the company. So it's subject to certain exceptions. And the main change under the new CO is to allow all types of companies, listed or unlisted, to provide financial assistance subject to satisfaction again of the solvency test and one of the 3 procedures set out in the ordinance, 283 to 289. So the first procedure, 283, provides that the company may give financial assistance if the assistance and all other financial assistance previously given and not repaid is in aggregate less than 5% of shareholders' funds. That is paid up share capital and reserves of the company, as disclosed in the most recent audited financial statements prepared for the company. The second procedure provides company may give financial assistance if it's approved by written resolution of all of the members of the company. And the third procedure is the company may give financial assistance if approved by ordinary resolution. And in this case, shareholders holding at least 5% of the voting rights or members representing at least 5% of the total members may apply to the court to restrain the giving of the financial assistance. There's been a change to financial assistance in relation to employee share schemes. I've given you some information in the literature. It's not my intention to say any more about that. It's quite technical. So all of these transactions in share capital, we've introduced a uniform solvency test. So I'm sure you're aware under Cap 32 at the moment there are provisions which involve solvency tests. There's a solvency test in respect of buyback from your own shares out of capital by a private company, sections 49K, 3, 4 and 5, and financial assistance to acquire shares by an unlisted company, section 47F. So both solvency tests are cash flow, no balance sheet, but there are minor differences between them. So for buybacks under 49K, it's required to be accompanied by an auditor's report. And for the financial assistance under 47F, there's an additional limb which provides for the scenario if the company goes into winding up within 12 months of the date of the assistance. So it was considered that it was desirable to introduce one uniform solvency test for all transactions relating to capital under the new CO. So that is what we've done. We have introduced this one solvency test. And it's basically based on the approach set out in 47F. We considered that gave clarity and certainty on how the solvency test applied in different scenarios. So section 204 provides for this solvency test to be applicable in relation to all three of the transactions, and section 205 sets out the requirements of the solvency test. So it's clear that there is no auditor's statement required, and the company satisfies the solvency test in relation to any transaction if immediately before the transaction there will be no grounds in which the company could be found to be unable to pay its debts, and either if it's intended to commence winding up within 12 months, it will be able to pay its debts in full within 12 months of the commencement of the winding up, or in any other case, the company will be able to pay its debts as they become due during the 12 months after the transaction. A solvency statement must be made and signed by all directors for buybacks and reductions of capital, and made and signed by a majority of directors for financial assistance. So the solvency test was something that was debated quite at length going through LegCo, and eventually, after a lot of consideration, we got it through in this form. And so hopefully this provides clarity, and the fact that it is uniform should be easier for practitioners to manage. Hopefully that is, again, a welcome development. Just another couple of issues before I sign off is just we've introduced this new filing requirement for a statement of capital. So under Cap 32, normally the structure of the company's capital, you can only ascertain it by going through the register and ascertaining from various different documents filed exactly what the position is. So we've introduced this idea of statement of capital, and anytime there's any change in the capital structure of the company, basically there's an obligation on the company to file this updated snapshot of what the capital of the company is. So much easier for people searching the register to find out exactly what the company's capital structure is at any given time. With the obligations to file, obviously there are criminal offences for non-filing. So this is a new obligation and just something to watch out for. Again, just some information. I won't go into that in detail. So basically, I'm sure you've all at some point had a look at the new ordinance. That's the link to the new ordinance where it can be accessed. As I say, the subsidiary legislation is now also up on our website. And there's also lots of information on the various parts of the Companies Ordinance, hopefully useful. A lot of the LegCo papers have been adapted for the public to have a look at. And there's lots of FAQs and any information that is not there. There is also going to be a hotline which will be manned, and phone calls will be welcome to ascertain any particular issues that cause concern. So just hopefully everybody will be geared up for its implementation in the 1st of March, and I just wish you all good luck with that. Thank you.
Thank you very much, Phyllis. Yeah, would you like to take the seat, and then we now well on time, and we have 15 minutes to go through our Q&A session.